Okay, welcome everyone to Inverse Condemnation Water World. Brief introductory remarks. My name is Evan Walker. I'm a solo attorney here in La Jolla, which is in San Diego, California. I'm a plaintiff's guy, so I represent people with personal injuries. It's about 60% of my practice. The other 40% is what I like to call property damage cases. So that's where you have first party or third party property damage cases. Why is that important for you? Well, that's how I got into inverse condemnation, which is what we will be speaking about today. I came across it in the context of property damage cases because this is how it develops. If I have a property damage case and it's a third party case, meaning it's the property owner against a negligent third party, not a first party like an insurance carrier, and that defendant is a public entity, anytime I'm faced with that scenario, the first thing I do when I look at this case, I say to myself, is this a case for inverse condemnation? All right. Now we'll get into it and you'll see why these types of cases crop up in what I describe as property damage cases. So a few introductory remarks here. Frankly, inverse condemnation is a nebulous area of the law. There's a lot of, I wouldn't say uncertainty, I would say confusion that comes about really once you start to dig in deep with the case law. Part of the problem, in my opinion, is that you're dealing with constitutional claims, but that also overlaps with tort claims, at least under the California Government Tort Claims Act. And that also gets into public entity immunity. And so you start very easily, you start to get, you can get overwhelmed and you can get confused when you start to look at inverse condemnation. Part of the problem too, which we'll hopefully make some headway in working through, is that some of the same concepts that any first-year law student will know from torts, proximate cause, reasonableness, are taken out of that context and used in the inverse condemnation context, which arguably, and at least traditionally, was limited to a strict liability analysis. So that's part of the problem. Part of the problem also is depending on what decade you're pulling your cases, you may think they stand for different things when other cases have come along and have refined that decision, but not explicitly so. And so what you can be left with is a host of kind of muddled thoughts when you're trying to work through this. So we're going to do our best to try to get some clarity on this issue. Something else to keep in mind is for the first time in over 20 years, the California Supreme Court has just handed down an inverse condemnation case, which is known as the City of Orville. We'll talk about that case. My position is that's going to be a very consequential case, and its ramifications are going to be felt for years, if not decades, to come. Now, getting on to the slides here. Focus is on inverse condemnation. Well, what does that mean? Well, this is California specific, all right? We're not speaking about other states. We're not speaking about federal law or the federal Constitution. We'll speak about the federal Constitution once, only to contrast it to the California Constitution. So something to keep in mind when you're thinking of inverse condemnation is, well, compare it to direct condemnation. Direct condemnation is where the government, through the power of eminent domain, pays just compensation for private property used for public use. In a direct condemnation case, this is what you have. It's going to be the government versus the property owner. Inverse condemnation is the exact opposite. That's where you're going to have the property owner versus the government. So the roles are switched. Getting back to the slides here, we're going to even narrow the focus even more. The focus is going to be on water in the context of inverse condemnation, hence water world. And so what that means is, and this is where also the case law gets confusing, you have to determine what type of water you're talking about, right? So there's stream water, surface water, and then everyone's favorite, flood water. So you always have to keep in mind the body of water that you have in your case. So what that means is we're not talking about landslide inverse condemnation cases. We're not talking about fire inverse condemnation cases, which we'll talk about at the end is currently a hot topic. We're just limiting this focus to inverse condemnation in water. And we're going to even restrict it a little bit further, where the narrow focus is on physical damage caused by water in the context of inverse condemnation. So what do I mean? I mean we're not talking about regulatory takings. Okay? There are really two classes of inverse condemnation. It's going to be takings, which 9 times out of 10 deal with regulatory takings, and then damage, and that's what we're talking about. So to take a step back, we're going to be speaking of property damage cases involving inverse condemnation where property was damaged as a result of water, whether that's stream water, whether that's flood water, whether that's surface water. That's going to be the focus on this case. So now that we've got that out of the way, what are the elements of inverse condemnation? Well, the case law is fairly clear about this. You need ownership, right? Then you need government substantial participation in the public project, all right? And we'll talk a lot about that. You also need taking or damaging of private property. Finally, you need causation. Now, a quick word about causation. We're not talking about negligence. However, wait till you see when we get to the city of Orville and how there's an argument to be made that now we're getting very close to negligence concepts and away from strict liability. So, moving on to the second slide here. So this is a quote from Article 1, Section 19 of the California Constitution, which is where inverse condemnation comes from. It's important, actually, just to read this out loud so we can get our bearings. Private property may be taken or damaged for public use, and only when just compensation, ascertained by a jury, unless waived, has first been paid to or into the court for the owner. All right. What's important about this? Well, if you look at the first part of it, it says private property may be taken or damaged. Well, compare that to the Fifth Amendment of the U.S. Constitution, which reads, and I quote, "Nor shall private property be taken for public use without just compensation." Well, what do you notice about that? Well, the Fifth Amendment for the U.S. Constitution doesn't have the word damaged. It has the word taken. The California Constitution has taken and damaged. So there's an argument that the California Constitution is broader in the context of inverse condemnation than the federal Constitution. And like I said a minute ago, 9 times out of 10 when you're dealing with regulatory takings, you're not dealing with physical damage at all. So it's important for our purposes, again, looking at water damage in the context of inverse condemnation, you focus on the damaged part of the clause of Article 1, Section 19 of the California Constitution. Well, what does that mean? Well, for California practitioners, it means you are outside the California Government Torts Claims Act, right? That's inapplicable. So the government immunity, the arguably onerous pre-filing requirements and time restrictions are simply inapplicable to an inverse condemnation cause of action. It's 100% outside that statutory framework. So let's move on. What's the first element? Ownership. So that's very broad. It's any interest in property at all. It doesn't particularly matter if you just have a leasehold interest or your owners in common or in joint, whatever. The rule is if you have any interest in property, you could have a claim for inverse condemnation. If you don't have an interest, of course, if all the elements aren't met, doesn't matter. You need to have an interest in private property. Now, what kind of property I'm talking about? Well, any type of property. Real property, which is your home, right? Personal property, which is your stuff. And even some cases say business goodwill. That's considered an interest of property. Now, we'll speak about this closer to the end of the CLE, but this raises ideas of subrogation, which is, I would say, even its own particular area in the context of inverse condemnation. This keeps coming up, and it's a very hot topic as well. And I'll speak very briefly about a case that I had a few years ago, just to highlight this idea of ownership. So I represented a family where it's a pretty nasty case where the public entity's sewage system backed up and it flooded their home. All right. The clients were renters, however. Right? They didn't own the property that was damaged. Now the home was damaged, no doubt about it, but they had no right to claim inverse condemnation damages because they didn't own the home. What they did own, however, was all the real property, all their stuff that got flooded with this nasty fecal matter. And so we made a claim with the defendant, and the defendant came back and said, we made a claim for inverse condemnation, and the defendant came back and said, you're not entitled to that. You don't own the property. And I said, I had to send him the law and said, frankly, you're absolutely wrong. Inverse condemnation applies not only to real property, but also to personal property. So, the adjuster was able to take that information and then, ultimately agree with us and pay the clients for the damage to their personal property under a theory of inverse condemnation. So let's move on here. This is the second element, substantial participation in a public project. What I want to do, I kind of want to break these down into two separate elements. So let's start with substantial participation. What does that mean? Well, the case law is fairly clear, and the operative word is fairly. Substantial participation means that the public entity planned, approved, constructed, operated, or otherwise was involved, read substantially, in a public project or activity for public use or benefit. Okay, so what does that mean? Well, if the government did nothing, there's no inverse condemnation. Now we'll see that that idea gets fairly nuanced in some of these cases, but you need to remember there has to be substantial participation, and that could mean that the government was doing something and then they stopped. Right? But if the government never did anything, there's no argument that there's substantially participated. There's possible inverse condemnation if the entity accepted and approved a public project like a roadway. Cases are clear about that. But again, you need to have substantial participation. And I'll speak just very briefly about another case that I was involved in where we represented plaintiffs where there was a very large flood caused by the failure of a levee. We sued a bunch of public entities and said, y'all are responsible for what happened. One of the entities came back and said, look, we had nothing to do with this. We were never involved. We had no involvement, no substantial participation. That's clear as day. And we fought about that in the court, but ultimately the court let them out and said, look, there's no, plaintiffs, there's no evidence of any substantial participation in the project by this entity, and therefore they're not liable in inverse condemnation. That was successful for that defendant, and they were let out of the case. So let's now talk about public project. Well, what does that mean? Well, importantly, it also means government activity for public use or benefit. Right? So the case law defines this as, quote, a use which concerns the whole community. So when I look at that, this is what I see. I don't see a set definition, right? I see that there's a certain, there's a broad definition with room for interpretation, and I would say room for discretion as to what constitutes a public project, what constitutes a public use. And that's where you see a lot of these cases are fought over. Because what happens is, it's ultimately a question of law. And under Civil Code, Code of Civil Procedure 1260.040, it could be decided under that provision, which reads, quote, if there's a dispute between plaintiff and defendant over an evidentiary or other legal issue affecting the determination of compensation, either party may move the court for a ruling on the issue. So again, you'll see this fight in these types of cases, whether or not the activity of the entity was done for public use or a public project. Now, it's a question of law, even if it involves questions of fact. The case law is clear about that. The limitation, however, is that the public use must be connected to the damage, right? You need to have a causal connection between the two. So let's move on here to the third element, taking or damage. Like I said, we're not talking about taking. Why? 9 times out of 10 that deals with regulatory takings. We're focusing on the damage piece of Article 1, Section 19. So you have on the slide here physical. That's what we're talking about. It has to be a physical damage to the property. You have to have it. The case law is 100% clear on that. So what does that mean? Well, physical invasion of the property, physical damage to the property, physical interference of the property. Now, we mentioned earlier goodwill. So cases say that you can recover goodwill, but there has to be damage to the property, right? You can't, there's no standing, there's no way for a plaintiff to claim loss of goodwill in an inverse condemnation context if there is absolutely no physical damage to the property. You need the physical damage requirement, all right? So in the context of what we're talking about here is, what that means is you need physically the water to come in and damage the property. You can't have the threat of water. It's not anything like that. You have to actually have the physical, tangible aspect of the water damaging the physical property. Now, getting back to CCP 1260.040, which we just quoted, the case law is clear that in regard to whether there's a taking or damage, that's a question of law. So, as you would imagine, this is where a lot of the cases are fought, as well as whether or not there's even been taking or damage, or whether or not, if there is damage, was it attributable to the government activity, which ties nicely into what we just discussed about substantial participation, right? Now, again, one way I find it helpful to think through this is, again, I just leave taking to the side and I ask myself, was there any physical damage to the property? Right? And if so, then you can start to spread out and explore the other elements of inverse condemnation. So what are some examples? Well, damage by water, like we just spoke about, escaping sewage, like we spoke about in that case that I had handled a few years back. So let's go on. Okay, now we're starting to get into some heavy-duty lifting here, hence my caution picture. Okay, you need a causal connection between the government activity and property damage, all right? Now, that doesn't mean negligence, so get negligence out of your head. But this is where the case law gets muddled. And it also gets complicated because there are, when you practice inverse condemnation like I do, you'll usually sue for several theories of liability, right? You'll have inverse condemnation, and then in California you're going to have dangerous condition of government property. That's under Government Code 835. Then you'll also have nuisance, and then likely trespass. And what you'll see as you start to work up these cases and motions get filed and demurs get filed is a lot of times the case law is overlapping, and sometimes, not all the times, but sometimes defendants come in and they start to misunderstand the law and they start to attack the alternative pleadings and kind of lump it all together, and things just get really, I would say unnecessarily so, but they get complicated, right? Because again, like I said earlier on, depending on frankly what decade you pull these cases, you may think that inverse condemnation stands for a proposition, but then that proposition or that rule was likely overruled by a later case, but not explicitly so. So it gets complicated. Now, speaking to that, the rule generally is that you need proximate cause. That's a negligence term, but you need proximate cause without considerations of fault. All right? So what does that mean? Well, it means that inverse condemnation does not involve foreseeability or fault, analogous to negligence. So traditionally, and what you'll see, we'll get into this, traditionally, when you're dealing with inverse condemnation, the theory of liability is very similar, not on all fours, but very similar to strict liability, right? But we'll see as we continue the CLE, there's arguably been a move away from that and a broadening of this reasonable read negligence analysis when you start to look at these cases. But taking a step back, generally the rule is you need a causal connection between the government activity and property damage. And like I said, that means proximate cause without considerations of fault. All right? Two exceptions to that. One, are any actions by the government taken under the police power, all right? And then two, what's known as the Archer exception. This came out, it was a Supreme Court case in 1950 or so, that what happened was you had two property owners. You had an upper property owner, owner of the upper parcel. You had the lower property owner, owner of the lower parcel. There was a stream shared by the two of them. What happened was the upper property owner diverted the natural flow of the stream and it flooded the lower property owner. Now, in that case, the court said there's no liability for the upper property owner under water law. And the court said that rule was applicable to government entities. All right, so that's the Archer exception. You'll see some cases, if you start to dig into this, get into Archer, but Archer, I would say, is arguably overruled. It's certainly questionable after another case called Laughlin, which we'll get to in a minute. Now, another case that's important to keep in mind in regard to causation is the Bel Air rule. So that's a case involving damage caused by construction and operation of flood control project. The rule out of that case is when you have damage caused by a flood control project, that the project's failure to function as intended is not enough to impose inverse condemnation liability. So this is, in my opinion, the first time you start to see a step away from this strict liability analysis more into the realms of negligence. So what Bel Air says is in the context of a flood control improvement, if there's been damage to private property as a result of floodwater, you need to show unreasonable conduct by the government entity, right? So it's not enough, again, it's not enough to say, okay, you had a flood control project, things went sour, and now the floodwater escaped and damaged the private property. It used to be that's enough. You'd say that's inverse condemnation. However, Bel Air comes in and says, no, that's not enough. You have to show that the entity did something unreasonable, all right? So the problem, one of the problems with Bel Air is it left unreasonable defined. Well, not so much defined, more like they didn't flesh out that idea. Right? What do you mean, court, in this context, in a flood control context? How is an entity unreasonable? How do you show that? That question was answered years later in the Laughlin case, which we just mentioned, and by introducing what are known as the Laughlin factors. So now what you need to understand in the context of flood control cases, the standard is not the traditional strict liability, rather it's the reasonableness standard introduced by Bel Air. So let's continue with causation, and now we're getting into our first type of water. So causation continued, water types, surface water. What are surface waters? Well, the case law is confusing, like I said. And so when you look at these cases and when you look at your case, one of the first things you need to ask is, well, if you're dealing with water damage to the property, what type of water was it, right? What type of water? So surface water are defined as rainwater diffused over a land surface, right? So what's the rule when you're dealing with surface waters? You can see there's a nice picture of some heavy rain here. The rule is this: the owner of the lower parcel, remember Archer, is expected to accept the natural drainage from the upper parcel. That's what's known in water law as a natural watercourse rule, all right? What happens, however, when the upper parcel owner changes the drainage and diverts the surface water? Well, in that case, the upper property owner is liable to the lower property owner if the upper property owner acted unreasonable. All right. Now, case law, looking with these facts, indicates that government, right, public entity, as the upper property owner, can avoid inverse condemnation liability if it acted reasonably, especially if the lower property owner acted unreasonably. So again, now you start to see Bel Air being applied outside of a flood control context, in the context of surface waters, right? Because we're not talking about flood water at all. We're not talking about flood control projects. Now,
the first code is 831. The first code is 831. The first code is 831.
Where it gets a little muddled as well is a case law, although it uses the terms reasonably, it doesn't mean reasonableness in like what you see in negligence cases. It's different. The case law speaks to a weighing of interest and behaviors. That's what they're talking about here. So let's move on to a second type of water. So causation continued, water types, stream waters. What are stream waters? Well, you see here in the picture, got a nice picture of a tranquil lake with a couple of ducks doing their thing. So what is stream water? It's water flowing in a fixed channel, okay, a river or a lake like what you see here. So what's the rule? Well, it's very similar to the surface water rule. The traditional rule was that one diverting stream water from a fixed channel to adjacent land is liable, right? That rule is applicable to public entities in inverse condemnation. Now, according to case law, there's inverse condemnation when construction by a public entity of a public project, for example, a dam, a levee, dikes, a culvert, or a canal, alters the flow of water in its natural channel. So getting back to this picture here of the lake, let's just say the city decides to build a culvert for, to drain the water, to do some type of public project. Let's say they want to implement a new development. And in doing so, it floods the owners of adjacent property. Case law says inverse condemnation. Okay, that's an inverse condemnation case. Also, according to case law, there's inverse condemnation in this context when damages are caused by the operation of the improvement as designed. So let's go back to this example I said by putting some type of canal on the side of this lake here. If it's operating as it's designed, as intended, and it causes damage to the adjacent property owners, inverse condemnation. What's interesting, again, to California practitioners, is you may know if you're dealing with either suing or defending public entities under the Government Tort Claims Act, you'll come up against design immunity, right? Which I would say is a very potent defense by the public entities. But again, knowing that we're outside of that context, what's interesting here is, according to case law, there is no, design immunity. Now, I know I said that we're outside of the context of the California torts claims, and we are, but it's very interesting to see that in this context, there's, design, doesn't matter if it's operating as designed, there's inverse condemnation. So what's an example of this? Well, I think there's a case that speaks about an entity removing dikes from the river and replaced it with levees. Okay, that caused damage. Court said inverse condemnation. Another example is when you have a building of levees for flood control purposes and that diverts water into private property, inverse condemnation. Older cases have dealt with the concept of foreseeability. You'll see that in the older cases, right? But more recent cases have departed from that analysis. Likely, if you have a case like this, if you're trying to analyze it, you're going to be stuck with Laughlin. So I have that mentioned here. So what's Laughlin about? Okay, this is an important case for our purposes. In Laughlin, the government constructed a storm drain, several systems of it, and made changes to the upstream property that caused increased volume of water into the natural watercourse, damaging downstream private property. So what am I talking about here? What I'm talking about is the facts of this case. The government had upper partial property. They constructed storm drain facilities on that property. What that did is it caused an increased velocity of water that was in a body of water, stream water, and it flooded the downstream private property owners. So this case was brought before the Supreme Court, and the Supreme Court held that the rule was whether or not the upper parcel owner, the entity in this case, whether their conduct was reasonable. All right? So we talked about that earlier. That's a natural watercourse rule, and they applied it to public entities. They rejected the Archer analysis, which we talked about. And like I said, I think there's an argument to be made that Archer is no longer good law. And instead, the court came in and said, well, we recognize what was discussed in Bel Air, and that there's an argument to be made that there's an unanswered question as to how do we understand what's reasonable? How do we gauge whether or not an entity was unreasonable in what they did? So the court in Laughlin gave the Laughlin factors. So the Laughlin factors are: you look at whether or not the public purpose is being served by the project, the cost of the project, the benefit of the project, the availability of alternatives, the severity of damages, the expected risk, and the degree to which the damage affected the plaintiff. You take a look at all those factors and you weigh them together, and then hopefully you reach a conclusion as to whether or not the entity was unreasonable and therefore liable for inverse condemnation. Now, something interesting about Laughlin is that Laughlin is limited to property adjacent to watercourse. So let's go back to this example. Let's just say that the city builds a culvert or a canal outside of this lake, diverts the water, and it floods neighbors. They're not adjacent property owners, but neighbors down the way. In that case, there's an argument to be made that the Laughlin reasonableness analysis doesn't apply, that you're back to traditional strict liability analysis. So let's go on. Okay, this is where it gets a little difficult, and that's why I said we have two caution signs here, because this is where we're going to start to get deep here. Okay. Causation continued. Water types, floodwaters. All right. What are floodwaters? That's easy. That's the overflow of water. The traditional example, which you'll see in insurance context, is outside water coming in. Right? We saw that in Hurricane Katrina all the time. That's what all those cases were about. It's outside water coming in. So that's easy. Okay, that's a definition of floodwater. That's the traditional definition, and that's what you see in these inverse condemnation cases as well. What's the rule? Okay, let's take a step back here. The rule for floodwater is this: inverse condemnation attaches if there's unreasonable acts or omissions by the public entities in the context of a flood control setting. We saw this, right? We saw this already with Bel Air and as refined somewhat by Laughlin. So what's an example of this? So an example, if there's been a failure of improvements that were been constructed to hold back floodwaters, levee, okay? That's a textbook example of what we're talking about here. And again, going back to Bel Air, you'll see I've listed a few cases here. We're just going to touch on very briefly to try to flesh out this concept and get a grip of what of what the current state of the law is. So Bel Air, again, we talked about this, but the Bel Air rule is that in cases involving damage caused by construction or operation of flood control projects, the project's failure to function as intended is not enough to impose inverse condemnation liability. You can't do it, okay? You need unreasonable conduct by the entity. So you may recall what happens after that. Laughlin comes in and says, look, here are the factors you use in this context to determine whether or not the entity acted reasonable or not. So you show unreasonableness or reasonableness by relying on the Laughlin factors in this context. But Bunch comes in later. And actually, if you start to dig into this, dig into the case law here, you'll see that there are actually two cases, Bunch. There's Bunch 1 and there's Bunch 2, but we're talking about Bunch 1. It involved a huge levee failure. Bunch 1 comes after Laughlin and says, look, inverse condemnation liability only exists if there's a combination between substantial causation and unreasonableness under Bel Air. So now you have another layer of complexity. So it's not enough now under Bunch to show unreasonable conduct under Bel Air / Laughlin. You have to show there's a combination between unreasonable conduct and substantial causation according to Bunch. Now, let's go on. Areola. I like this case. So let's see what Areola has to say. Okay, so here are the facts of this case. Areola involved a levee built by the Army Corps of Engineers, so an arm of the government, I think in the 20s or 30s. So the Army Corps comes in, they build this levee, and they say, look, public entities, do y'all want this levee? You need to be responsible for it. Okay, but we'll hand it over to you. So a number of entities, I think there was the county, maybe the city, perhaps even the state, but I know there were multiple public entities came in and said, okay, we'll take it. And so the Army Corps of Engineers basically, gave them the levee and said, well, I want you to maintain it. So what happened was the entities at first used mechanized clearing of the levee, right? Because over time, vegetation would grow up and start to impair the functioning of the levee. And so the entities were hiring, I think they probably third-partied out, hiring these companies to go in there and do this mechanized clearing of the buildup over time. What happened, and this was disputed in the case about as to why, but what the court seized on was that the entity stopped doing it, right? They stopped the clearing. And so what happened over time was that the buildup came back, and you had this vegetative buildup of the levee, and that in turn blocked the water flow. And so eventually the plaintiff's property flooded. So the plaintiff sued everyone in strict liability, went up to the appellate court, and the appellate court looked at the facts and said, look, the entities are liable for inverse condemnation. Why? You're in a flood control context, so what's the rule? It's Bel Air / Laughlin reasonableness, because what they did was unreasonable. They knew the risk of the flooding, but they didn't act. So this is important, I would say, from a plaintiff's perspective, because these cases are getting difficult. We'll speak about that more in a minute. But what Areola brings to the table is that the entities started to do something and then they stopped, right? So this ties into what we talked about early on with substantial participation. You may recall that I said that in some contexts, substantial participation could mean omissions, right? So here you had these entities taking some affirmative action that were preventing the flooding of property by clearing the vegetative buildup, and then they stopped. And the court looked at that and said, that was unreasonable. You knew the risk of flooding and you didn't do anything about it. Or you stopped doing something about it. And so inverse condemnation under the Areola case. Okay, strict liability. Let's switch gears somewhat. I want to talk about two of my favorite cases, Pacific Bell and McMahon's. Why are they my favorite cases? Well, because you're getting back to I would say, the traditional inverse condemnation strict liability analysis. These cases, I think, are fun because these cases in particular, because they're somewhat easy to digest. So what are the facts of Pacific Bell? Okay. Plaintiff's property flooded when a cast iron water pipe burst. Okay? Plaintiff, who actually, Pacific Bell was the insurance company, the insurer for the property owner, which gets into subrogation. We'll speak to that closer to the end, but it was actually brought by an insurance company against the city of San Diego. So they sued San Diego and said, inverse condemnation. Why? Because the pipe that burst was part of a water distribution system. What's that? Well, that's a public project, right? Or it's a public use. And it was being operating as intended, therefore strict liability, inverse condemnation, pay us. San Diego pushed back and said, no, what are you talking about? This isn't operating as intended. We don't intend our pipes to break. What you're saying, plaintiff, make no sense. So this got before the court, and the court sided with the plaintiff and disagreed with the city and said, no, it is operating as intended. Why? Because plaintiffs learned that the city had to wait until it breaks policy, right? There was no affirmative steps on the city to go out here and replace the pipes. The city's policy was, well, when a pipe breaks, we'll fix it. Okay? And so the court said that's deliberate. What you see here is the city's public project operating as intended, right? The pipe breaks, the pipe breaks, the city fixes it, right? So the court came in and said, look, we're not even getting into this unreasonableness. This is strict liability, boom, city, you're liable for inverse condemnation. Very similar case. This is McMahon's, I think, versus Santa Monica. Very similar. Water main broke, damaged the plaintiff's property. The city pipes were corroded, and the court seized on the fact that the city failed to replace the pipes, similar to what you saw in Pacific Bell, and said they're liable in inverse condemnation. Right? We don't even have to think about this unreasonableness standard. They're liable. I would say strict liability. So that's what you see in those two cases. The last thing I'll say on the causation in the context of floodwater is that if you have flood control improvements operating as intended and it floods property, to prevent flooding of other property, you have strict liability. So that's somewhat confusing, so let me kind of break that down. If the entity goes in and they construct a project that deliberately floods property A to prevent flooding to property B, the city is liable, or city entity, whatever, is liable in inverse condemnation under the umbrella of a strict liability analysis. Right? That's what some cases say after this. So now let's go on to the laws we find it today. City of Orville versus Superior Court. I'll read briefly. I'll read the quote that you see in front of you in a minute, but if you could just listen to the facts of this case, and then I think the quote will be important and you'll understand it easier. So on August 15th of this year, the Supreme Court handed out the first decision of inverse condemnation in over 20 years. This is a big deal. I mean, this is hot off the press. Like I said, I don't even think it's been 45 days since this case was handed out. And so my prediction is going to be a very important case, and it's not really a case favorable for plaintiffs. So what are the facts of the case? Facts of the case were a group of dentists sued the city of Orville when sewage came through the city pipes and damaged their offices. So pretty nasty affair. The dentist sued the city in inverse condemnation. The city came back and said, fellas, no, you should have installed a backwater valve. If you would have done that, it would have prevented the sewage. Okay? You didn't do what you needed to do. Trial court and the appellate court said, no, inverse condemnation. Okay? Clear inverse condemnation, no questions asked. The city appealed it to the Supreme Court. The Supreme Court reversed and said, no inverse condemnation. So what the Supreme Court held in that case, and this is important, was that inverse condemnation is only successful when the property owner, right, shows property damage, and I quote, was a probable result or necessary effect of an inherent risk associated with the design, construction, or maintenance of the public improvement. Okay. So what did the court focus on that case? We'll talk about that, then we'll read this quote. What the court focused on was causation. Okay? Really hit home on causation. They talked about, which I found very interesting, and we'll speak about this near the end, the increased cost to the government for inverse condemnation cases. They focused also on the dentist's actions and also on the city's actions, which the court found to be reasonable. All right? So, let's look at this quote. The quote, and I find this to be the most important quote of the case, and if anyone has any interest whatsoever in inverse condemnation, read this case. I mean, look at the other cases we talked about, but you have to read this case through. So, excuse me, a court assessing inverse condemnation liability, remember we talked about a lot of these things are legal issues. I think this is what the court's speaking at here. Must find more, that's my emphasis, than just a causal connection between the public improvement and the damage to private property. So stop right there. To me, what that means is strict liability analysis, that's not good, right? You need something more than that. Continuing on, what we hold is that the damage to private property must be, my emphasis, substantially caused by an inherent risk presented by the deliberate design, construction, or maintenance of the public improvement. Okay, so what's going on here? Well, my understanding is this, is that the takeaway of this case is that what you see is a move away from the strict liability analysis that was illustrated in the earlier cases to more of the reasonable analysis that you see in Belair and Laughlin in a flood control context. But now we're outside of a flood control context, right? So if you think about what we just talked about, this case, I would say factually, is very similar to what you saw in McMahon's and Pacific Bell, right? But what you see here is the court saying, look, now we're going on to, we're getting away from this strict liability analysis, and we're moving toward this reasonableness analysis that was announced in Belair and Laughlin, and arguably limited to the flood control context. So, all right, we have a few minutes left here. Let's talk about just compensation, all right? So what's the rule here? Well, there's no problem with the government taking or damaging private property. There's nothing illegal about that, right? Only if it happens, the entity has to pay just compensation to the private property owner, right? So what's that mean? Well, fair market value is the general rule most of the time. There is an exception, however, to cost to repair to the property. We don't have time to get into that. But you'll see that if you ever practice these types of cases, you'll see that exception, all right? This, unlike the other issues we talked about, is a question of fact, right? And it's a right to jury trial on that issue. You may recall one of the first slides when we talked about Article 1, Section 19 of the California Constitution. We quoted it in full, and it talked about the issue of just compensation being decided by a jury. So this is the factual question, all right? It's based on what was lost. So you look at fair market value. Compare that to eminent domain analysis, right? So that's when, the government would come in and they want to condemn a property because they want to use it for, public use. In that context, the court has to, not the court, the entity has to come in and there has to be some agreement as to what's the fair market value of the property. Same thing here in the inverse condemnation context. But, again, coming full circle to what we talked about in the beginning, you need physical damage to the property, right? That's a definite requirement here. The damage simply cannot be a depreciation of market value, right? That's not enough. The case law is clear about that. So again, coming again to full circle what we talked about in the beginning, as to ownership, any person with a property interest in the property is entitled to recover. Okay? So what are the recoverable damages? That's the second question here. Well, if the property was completely damaged, wiped off the map like we saw back in Hurricane Katrina, fair market value on the date of the taking, okay, are damaged. If it's not completely damaged, then you're entitled to the diminution in market value. All right. Remembering, as always, you have to have physical damage to the property. Now, like I said, there is a cost to repair exception. If you litigate these cases, you will come across that. You also get interest from the date of taking or damage. Now, this is the explosive issue of inverse condemnation. And I think it's what drives a lot of these cases, is under Code of Civil Procedure 1036, the plaintiff is entitled to attorney's fees and cost. So what that means is this is arguably a potent weapon for the plaintiffs, and it's something that the defendants know if they're faced with a legit inverse condemnation case, is that the plaintiff is entitled to attorney's fees. Now, case law, I think there's a recent case that just came out and clarified this issue more, and I forget the name, but the attorney's fees that are recoverable under inverse condemnation have to be strictly tied to the work done on inverse condemnation, right? So like I said earlier, when I have these cases, I'll sue under inverse condemnation, dangerous condition, trespass, and negligence. But I have to keep up with my time as it's related to the work I've done to inverse condemnation. Okay, you have to separate that out, right? So that's going to be important, because some cases have come out and said, look, you can't just take a carte blanche move and say, give me all this. No, you have to show this is the fee related to the work you did on inverse condemnation. All right. Now, what you will see if you start to look at these cases is sometimes these costs and attorney's fees are higher than any of the hard numbers that the plaintiff, the property owner, gets, right? You could have a fair market value case of $20,000, and for whatever reason, the case stretches on for a year and a half, and you have to hire engineers, you have to hire hydrologists, and all these costs start to add up. So you can have $20,000 hard numbers. You can have $120,000 in attorney's fees and cost, right? So now, what's my math? $150,000 case? You went from a $20,000 case to a $150,000 case. So that's why this is such a hot topic issue. We'll talk about this very briefly at the end, because of the potency of the attorney's fees and cost under Code of Civil Procedure 1036. So lastly on this slide, subrogation. I spoke about the Pacific Bell, how that was brought by the insurance company. And you see that a lot. There's case law that came out that said insurance companies have a right to subrogate and to collect not only what they paid, also for attorney's fees and costs under CCP 1036. So that's a huge business, and you see insurance companies doing this. And I would say that that's what you see in PG&E's bankruptcy. Okay, so that brings me to the last slide here, and we'll talk a little bit about that. So, conclusion, what's the landscape going forward? Well, we limited this discussion, intentionally so, to water damage. Because like I said early on, this is a very confusing area of the law, and it's very nuanced. And it's changing, right? I mean, you saw this with the City of Orville case that just recently came out, and I would say just kind of changes the course of inverse condemnation. Now, let's talk very briefly about what happened to PG&E. So if anyone's picking up the paper, you realize that PG&E, a huge utility company, recently filed for bankruptcy following these devastating fires. And I would say there's an argument to be made that one of the reasons that PG&E did that is because of a very serious concern for plaintiffs and insurance companies insuring those plaintiffs coming after PG&E for inverse condemnation, the attorney's fees and cost, right? So let's go back to this example I talked about. PG&E could have had a $25,000 damage, property loss, or could have paid and be done with it. But now, under inverse condemnation and CCP 1036, that $25,000 case is now a $150,000 case. So you multiply that by hundreds and hundreds and hundreds of claims, and you get to where PG&E is, in my opinion.
The second code is
867.
the second code is
867.
the second code is
867.
So, very quickly, well, some of you astute listeners may say, well, PG&E is not, it's not a public entity. Well, that's correct, right? But there is case law that says when you have quasi-public entities like a utility company, they are liable for inverse condemnation, right? And I'm fighting that in one of my cases, and you see that in one of the wildfire cases that I have where it's an inverse condemnation case, right? And they're coming in and saying, look, we're not responsible, we're not a public entity, and frankly, they're losing the argument in court because the case law is starkly clear that in those contexts, utility companies are considered public entities for purposes of inverse condemnation. All right. Now, like I said, the attorney's fees and costs recoverable under CCP 1036 can make these cases almost a multiplier of hard numbers of recoverable damages, and that's what can make these cases so dangerous to defend and important for the plaintiffs. Real briefly, what you also see too by utility companies and some other interested parties is they're trying to make changes through the legislative branch in order to change this law. And you also see an attempt somewhat in the judicial branch to do that. The problem is that inverse condemnation is a constitutional claim. So if the law has to be changed, arguably the California Constitution has to be changed, right? But what you're seeing instead, at least at this time, is courts becoming a more conservative, restrictive approach when they're looking at these inverse condemnation cases. And so I see the best example of that is what you saw in the city of Orville, which again I would say represents a move away from the traditional strict liability analysis of property ownership, property damage caused by an entity's substantial participation in a public project, over to, well, all those things are given, but let's see if what the entity did was unreasonable, or was it reasonable? And so I would say that opens up a little bit of discretion to find that these entities were not liable. So I would say from a plaintiff's perspective, that starts to make these cases more difficult, and my opinion would be the city of Orville is a decision that's going to be relied on very heavily by defendant public entities in these cases going forward. But not to leave on a sour note, here we have clips of our buddies Dennis Hopper and Kevin Costner and the lost 1990s gem of Waterworld. If you haven't seen it, please treat yourself to it, and we'll leave on that note. Thank you.